Hello, my name is Randall Borden. I'm an attorney in Maryland and Virginia. My office in Fairfax City is outside of Washington, D.C. in Northern Virginia. And I also practice in Maryland, in Montgomery County, and in Frederick County, Maryland. A family law lawyer, and today I'm going to be talking about spousal support. I'm going to break that down into two parts. One is temporary spousal support that you get before the final trial in a divorce, and the other part is permanent spousal support, or the spousal support that you would be awarded in a trial. Temporary spousal support is obviously temporary. In Virginia, it's called pendente lite, which means pending litigation. So it's awarded from the day that you file for pendente lite spousal support up to the day of trial. So if you do have a divorce pending, you should file a motion for PL relief, pendente lite relief, before the trial. You can obviously going to get spousal support, but you can ask for other things like that your spouse doesn't spend out the money, doesn't, sell any property, that kind of thing. And you can also get child support, pendente lite child support if you have children also. So the typical scenario is it's a very short hearing. You have to file the motion and the court will schedule a hearing. It's usually about a half an hour hearing, and you present sort of your basic facts, then the judge awards it based on that. So in a typical PL supports or spousal support, you obviously have to show your income, show the husband's income. You would want to show other things like your health insurance and things like that. Again, if you're also asking for child support, you would need to show the daycare expenses and any special needs for the children. But the court makes the decision based on the gross income of both of the parties. So that includes income from all sources. So obviously working, they go with the gross amount of your salary, not the net amount. So the court will not take into consideration any deductions. If you are self-employed, then you have gross income minus reasonable and necessary business expenses. When you're self-employed, you are allowed to deduct expenses from your gross income. If you don't put on evidence as to your necessary expenses, the court could award the support based solely on your gross income. So you want to really make sure you're careful about that. But it also includes income from all sources. So if you have child support from another parent with another child, if you have income from rents, interest, dividends, that kind of thing, all of that would be included. And so the court then applies a percentages in the code, Virginia Code 16.1, 278.17:1 talks about spousal support, temporary spousal support. So if you have children, it is payor's income minus the payee's income, but a percentage. So it's 26% of the payor's income, the person who's going to be paying the spousal support, minus 58% of the payee's income, the person who's going to receive the child support. So that's the situation if you have children. If you do not have any children, it's 27% of the payor's income minus 50% of the payee's income. But roughly, those are the numbers. And mathematically, it generates a positive number only if there's a big difference between the incomes. So if the payor has a very high income, the payee, the recipient, has little to no income, there will be a big number there for spousal support, temporary spousal support. But if the amounts of the income are close, you can see that it comes out to zero or a negative number, and the court will not award temporary spousal support. So a lot of people, but you can still qualify for spousal support at the trial, and that could be permanent or have a time period attached to it. So just because you cannot get temporary spousal support, you still have the option of asking for and proving your need for permanent spousal support. So using those two numbers, I think it's a lot of people, and of course, flip side is not true. So just because you qualify for temporary spousal support, or you get temporary spousal support in a very precise calculation, that calculation, 26% minus 58% or 27% minus 50%, those numbers do not apply when you're proving your need for permanent spousal support at the final hearing, the final trial. So a lot of people get upset or disappointed because of that. So that is a choice that was made by the state legislatures to leave it up to the discretion of the judge rather than apply an actual mathematical formula. It's at the discretion of the judge to determine how much spousal support the person deserves, or if any, if they may not deserve any spousal support. So the way that works is you go to the factors that are also set out in the Virginia Code, and that's where you calculate the amount, or you do not calculate the amount. It's actually up to the judge to determine what the factors that would apply, and then based on the judge's decision. So the first factor are the obligation, needs, and financial resources of the parties, including income from all sources, including distributions from retirement plans. You start getting into the lifestyle, obligations, needs, and financial resources. So what are you obligated for? Like child support, obviously. The needs, what do you need to live? I mean, rent, car, food, clothing, that kind of thing. And also financial resources. Do you have resources from other places? Do you have a giant pension plan that you're going to be able to tap into? Well, okay, but if you have a big retirement plan, then that's one of the factors that lessens your need for spousal support. Or if you're going to get a portion of your spouse's pension plan in the ultimate division of the assets, then that can see you through, and it lessens your need for spousal support. Factor number 2 is the standard of living during the marriage. And again, you would want to put on evidence as to a nice home, regular vacations, private school for the kids, that kind of thing. And so that's one of the factors the court considers, is what your lifestyle is, or, middle income, upper income, that kind of thing. So that's, as you get into the upper echelon, you can kind of see that you're now arguing for essentially luxury items in your lifestyle that you had beforehand. You had always belonged to the country club, or you had always had horseback riding lessons or something like that. So number 3 is the duration of the marriage. How long had you been part of this partnership? There's a general feeling or an unspoken, unwritten rule that a 10-year marriage qualifies you for spousal support. That's not a hard and fixed rule, but it is good to keep in that 10-year mark is good to keep in the back of your mind. But basically, you have to have a long marriage to qualify for spousal support. Not all again, these are not fixed rules. It's not like the hard percentages that you see in temporary spousal support. But the idea is that if you haven't been part of the marital partnership for a long time, you really don't deserve the benefits of the marital partnership, other than, say, dividing the assets. Number 4 is age, physical, mental condition of the parties, and any special circumstances of the family. So young, healthy adults, they can continue working, less of a need for spousal support. Physical and mental condition, that's obvious, speaks for itself. And then special circumstances of the family. And again, that's something you'd have to prove. Obviously, physical and mental condition of the parent or of the spouse, physical mental condition of the children, which we'll get to actually next. And then the question is, what are the other extra special circumstances? So that would have to be put on also. Number 5, the extent to which the age, this is the children, the extent to which the age, physical, mental condition, or special circumstances of a child would make it appropriate that one of the parents stay at home or not work outside the house. So again, very young child with special needs, it's probably better off that the parent stays with the child instead of getting a job and then paying someone to stay with the child. And of course, this could maybe qualify you for a short-term spousal support. Once the child reaches a certain age, the spousal support could end. So you may have a 5-year spousal support, and then your child goes to school and you're expected to go back to work. Or, situations where the child's condition is permanent and is so bad that it just makes sense that the parent stays at home and cares for the child. Number 6, contributions for the well-being of the family. That could be monetary and non-monetary. The typical circumstance is the husband's out working, he's making monetary contributions, the wife is staying at home caring for the children, but she's making the non-monetary contributions. So again, if you think of this as a partnership analysis, that the partnership was the father goes out and makes money, the mother stays home and raises the family and maintains the household. Now the partnership is being dissolved and each partner deserves their fair share of the partnership. So the non-monetary contributions that you'd want to show what that spouse has been putting into the marriage. And again, the most typical is staying at home, raising the children, taking them around to the soccer and piano lessons and that kind of thing. So, and that of course frees up the father to continue working, building his career. And now, the partnership is dissolving. Each partner should be treated equally. So number 7, the property interests of the parties, real property like real estate, personal property, tangible property, bank accounts, brokerage accounts, intangible property. So again, and of course that's just the marital. Well, you would start off analyzing the marital property, what was built, what was acquired during the marriage. But also if one of the parties has some outside funding, of course that goes back to number 1, financial resources of the parties. So the need for monthly income from spousal support, if you have wealth already, or if you have a lot of other assets, then it of course lessens your need for the spousal support. And then number 8 is of course exactly the provisions made for marital property. So again, if you get a big portion of the retirement plan, well, you'll have that for retirement, so you don't really need spousal support for retirement. That would be the argument. Number 9 is the earning capacity of each of the parties and their ability to get skills and training to become big earners. The earning capacity, including skills, education, and training of the parties, and the present employment opportunities for persons possessing such earning capacity. So could one parent, say the parent who's been staying home with the kids, now that the kids are off to school, what's the possibility or the qualifications of that parent to get trained to re-enter the workforce? So that would get into obviously the previous level of education, high school graduate, college graduate. How long has it been since that parent was in the workforce? Nowadays, workforces are changing so much, the entire job might be gone. Think of it as a secretary who doesn't know how to use the latest software, or a man who is great at repairing TVs, but nobody repairs TVs nowadays. How long would it take that person to get retrained? How much would it cost that person to get retrained? What kind of skills would be necessary for that? And how much would it cost? So if the other spouse graduates successfully, then they would be able to earn $60,000 a year instead of $30,000. Something like that. So that is where you have to put on the party who doesn't want to pay spousal support has to put on that evidence and say, well, maybe I'll pay spousal support, but only for 3 years, but I'll pay for the tuition also. Then 3 years, it's over and done with. So they don't want to pay spousal support for life. On the other hand, a long-term marriage, 40 years, the wife is completely out of the workforce that whole time. The habits or the lifestyle was the husband works and the wife stays home. What are the chances the wife could go back to school and learn a new skill? Learn Microsoft Office, for example. Probably not real good, especially if she's older. There is age discrimination. As much as people like to pretend it doesn't exist, it exists. So once the employer sees how old you are at an entry-level job, you know the rest of it. So that might be an argument agreement for lifetime alimony, or at least alimony until retirement, and that the spouse can start getting retirement income, Social Security, Medicare, that kind of thing. Number 11 is decisions made regarding employment during the marriage. And that's where you get into, it's very closely related to the previous one, where the decision during the marriage was stay-at-home wife, husband's out working, they have kids, the mother maintains the household, raises the kids. Even as the kids go to school, the mother's always there, making sure the kids do their homework, taking them to sports, to athletics, to ballet, to piano, etc. And that has been the arrangement of the family. The husband moves up on his career ladder, and all he has to worry about is advancing in his career, and the wife, the stay-at-home wife, has handled everything else. You know, the Christmas parties, sending out Christmas cards, birthday cards to his associates so that they keep him in mind, all of those things. And that's where you'd want to build up the partnership model of the marriage, that the arrangement that both of the parties agreed on was it's approximately 50-50. The husband earns the money, builds his career, and the wife builds the family. And then, you know, as time advances, promotes the husband's career. So you would want to present all of the evidence as to the children, stay-at-home mom, cooking, cleaning, homework, going to all the different events, parent-teacher meetings. But then once the children are grown and left, then you would want to show that the wife, the stay-at-home wife, didn't need to work. I mean, the husband was doing very well and was helping the husband in his career. That, you know, she was the one making sure everyone at work got like I said, Christmas card, birthday card, and got gifts, got noticed, etc. And she would host parties for the husband's associates. They could come, they'd see the beautiful house, have good feelings about a good, solid, reliable family man, someone that you could count on at work, etc. So that's how you'd want to present that one to the court. And so it actually covers that the arrangement made by the parties during the marriage and their effect on present and future earning potential, including length of time that one or both of the parties had been absent from the job market. So again, as the stay-at-home wife is building the husband, you know, her skills are just getting less and less valuable in the workplace. Number 12, the extent to which either party has contributed to the attainment, training, career position, or profession of the other party. The typical example there is the husband and wife meet in school, they fall in love, they get married, and one party, usually the wife, will drop out of school, get a job to put the husband through college and medical school or whatever, and that her money goes to promote his education or his training, and now that he's arrived, you know, at his spot, he wants to divorce his wife. And that's where the partnership model would also apply, and you would want to put on evidence as to what the wife was doing previously. They were going to college, the wife had plans to become a whatever, and the husband wanted to be a doctor, and then the wife dropped out to promote his career. And of course, again, a stay-at-home mom, that's in the previous one, even after the kids go off to school and move out of the house, if the stay-at-home mom is still promoting her husband at work, social settings that have, you know, continuously improve his status as a worker or improve his status as selling items or a business manager or whatever, again, the partnership model says that the wife should get her share of that. And then number 13 is other factors, which include other factors, but the ones that they specifically mention are tax consequences. So it's, you know, what happens if you just cash out your retirement plan? What happens if you sell the house? Who's going to pay those taxes? The factors that led to the dissolution of the marriage, and which are normally the grounds for divorce, whether it's, you know, adultery, alcoholism, drug abuse, domestic violence, that kind of thing. That's just to balance things out as the final catch-all opportunity for the judge to make things right. So, as you can imagine, each one of those factors has enormous numbers of cases that talk about this particular husband and wife, and this was the situation, and the judge is going to apply this factor. And what you really need, or what the way that my office operates, is if you hire us, we have about a 2-hour interview, and we go through, I have 200 questions just to try to show typical day in your life, just so we know all of these factors. And there's similar list of factors for child support, child custody, child visitation. There's a similar list for dividing up marital property. And so this 2-hour interview with my office, we try to gather all of that and then apply it to each of the cases, each of the listed out factors right here. So that is the two ways you get spousal support. One is temporary spousal support, and that's a quick application of two percentages. And then the other one is the longer one, and that's where you identify all of the factors and try to touch on each one of them, why it's in your favor, or if it's against you, why it's not really against you, or why it's not that important, or this factor offsets that factor, things like that. So that's the job of your lawyer, or a big job if you want to do it yourself. So this is YouTube videos, so please like, that makes a big difference. Subscribe, that makes a big difference. Let me know. I have other videos, so please, if you like this one, please look at my other ones. Also comment. Let me know what you think of this, how it's good, how it's bad, other videos that you'd like me to make. So again, thank you for going this long into it. I appreciate that. It's not a short answer, but again, my name is Randall Borden, attorney in Maryland and Virginia, family law outside of the Washington, D.C. suburbs, Northern Virginia, and Southern Maryland. I appreciate your time. Thank you very much. Bye.